Is there any reason why you can't come in here today to set up your work days and set up some kind of payment arrangements?
Yes, because of transportation.
Okay. When could you do that? When could you get a ride up?
Possibly if I could, probably next week or this week, but
If
just
I
by
give
the
you
end of
until
the week,
Friday at 3 o'clock, do you think you can get in
because
here?
everybody's working right now.
If I give you until Friday at 3, do you think you can arrange transportation?
Yeah.
All right. Do you have any questions at all?
No, thank you.
All right. Have a nice day.
You too.
Thank you.
Thank you.
Thank you.
There's no way turning on that one either.
Where are the guys at? You don't have to be running these.
Fine.
Dante Johnson.
Yeah,
Good morning, Mr. Johnson. Are you going forward today without benefit of a court-appointed attorney?
yes, I am.
And did you understand your rights that you have today and the options those rights present to you?
Yes,
And how about the charge? Do you understand the possible penalty for the charge of registration or plate misdemeanor?
yeah,
Understanding all of this, Mr. Johnson, are you pleading guilty to that charge today?
yes.
Are you doing so freely and voluntarily? Are you pleading guilty because you've decided that's best for you or because
was
somebody's
that?
telling you you have to? Are you having trouble hearing me, Mr. Johnson?
Yes, I'm pleading guilty.
Okay, we just lost you. Heather, where is Mr. Johnson located right now?
Livingston County Jail.
He just froze up on us.
Yeah, I see that.
And
He's gone now.
gone. Yep. Hopefully we'll get him back. Mr. Graziani, your appearance for Fuller.
Good morning, Judge. John Graziani, P number 43387 on behalf of Jamil Fuller. Please introduce yourself, Mr. Fuller.
Jamil Fuller.
Hey, Heather, Mr. Fuller is not on my printed docket, but I do have a file.
He is not.
Oh, he's an
Marlisa
add-on.
added him. Yeah.
I found him. I
Yep.
found him. Okay, just wasn't in alphabetical order. All right, Mr. Graziani, tell me what we got.
What's happened is Mr. Fuller originally had a reckless driving charge, discussed this matter with Prosecutor Manorino, and she's agreed to dismiss that and have Mr. Fuller plead responsible to careless driving, sir.
All right, Mr. Fuller, is that the way you want to resolve this today?
Yes, sir.
All right, and you've discussed your rights with counsel. You understand those rights?
Yes, sir.
Understand the options those rights give you today?
Yes, sir.
All right, I'll accept your plea of responsible to careless driving, dismiss the reckless. How long has he been where he's at, counsel?
I believe for about 3 months. Is that correct, Mr. Fuller?
No, I've been here since March 2nd.
Okay, I apologize. He caught a gun charge earlier, and I presumed he was there a little bit longer, Judge. My apologies.
How long are you going to be there, Mr. Fuller? Do you know?
My sentence is 1 to 5, but I'm boot camp. Boot camp has permitted me. My judge in Wayne County has permitted me to go to boot camp. So I'm just waiting for boot camp to come and give me that's 90 days.
Man, I hope you know how lucky you are.
100%.
Wow, that's a gift, man. Don't screw that up, Mr. Fuller.
No, sir.
All right.
Judge, would you want me to deliver the plea form to your courtroom?
No, I don't need it.
Okay, thank you, sir.
All right, I'll waive or suspend fines and costs on the careless. You go take care of business in boot camp. Take advantage of
All
that.
right,
gift.
Thank you.
Thank you,
You're
Judge.
welcome.
Thank you.
Heather, are we done with the jail?
No,
With him, yes.
All right.
Heather, can you get me the next person?
Yep, they're in your meeting room. If you can go back in your meeting room,
Okay.
you can't.
Mr.
All
Fuller,
right.
just let the deputy know we're done with you. Thank you.
All right, I got you.
Do I press more? Where do I press, Heather?
I don't know, John.
Okay.
I don't have your computer.
Counsel, your appearance on Harrison.
Thank you, Judge. John Graziani, P number 43387. Sir, I'm representing Mr. Harrison. Mr. Harrison, please enter your appearance. Please identify yourself, sir.
Yes, Your Honor. I'm Xavier Harrison.
Thank you. What do we
Yes.
got, counsel?
Judge, what's happened is Mr. Harrison's availing himself to 771.1 plea. He does not have a criminal history. I spoke with Prosecutor Manarino, and she has no problem with it. The recommendation is for a period of 6 months, and I've explained all the rights associated with that. The fact that Mr. Harrison still could go to jail, and then he's got a right to go to trial, bench or jury trial, and other things with the advice of rights, and he does want to enter the plea at this time, Judge.
Thank you. I think I talked to your passenger a few minutes ago.
Yes, Your
You
Honor.
guys work for the company that hauls appliances around for the big box stores?
Yes, Your Honor.
Yeah, okay. And did you understand your rights after talking to Mr. Graziati about same?
Yes, Your Honor.
You understand the options those rights give you?
Yes, Your Honor.
Understanding all of that, are you pleading guilty freely and voluntarily to this charge?
Do you understand the
Yes, sir.
charge, Mr. Harrison?
Yes, Your Honor. I do. Yes, Your Honor.
You're
Yes.
pleading freely and voluntarily, sir, correct?
That of
You're
what
pleading
happened this
guilty
morning.
because you decided that's best for you, not because Mr. Graziani told you you should.
No, Your Honor.
Nobody's
sorry.
correct.
I'm sorry.
He's-
I'm sorry, Your Honor. I'm sorry, Your Honor. I didn't mean to ask for an attorney. I'm sorry about that part. But yes, Your Honor, that I had the firearm myself. Yes, Your Honor.
Okay, all right. So my understanding from talking to your truck mate
Yes, sir.
is that you guys are traveling in Michigan on delivery. You had a pistol and loaded magazine in the vehicle. Neither one of you had a concealed pistol license. And in Michigan, that's improper transport of a firearm. Is that
Yes,
the
Your Honor.
factual basis?
Yes, Your Honor. It was unloaded. It was away from each other. It was unloaded. Nothing was in
Yeah,
it.
but
Nothing was in the.
The
Satisfied,
loaded
Judge.
magazine and the pistol were in the same compartment, correct?
Yes, Your Honor.
All right. Mr. Graziani, is satisfied?
Satisfied, Judge, satisfied.
All
sir.
right. Mr. Harrison, how long have you worked with the company?
For a year now.
Okay. All right. Anything else you want me to consider before I set the terms of sentence?
No, Your Honor.
Okay. As I told your coworker, usually on a charge like this, I would order work program days, but because you're an out-of-state resident, I'm going to convert that to community service hours.
Yes, Your
So
Honor.
court costs are $500, 20 hours of charity work. I gave him 60 days to get the charity work done. I'll give you the same.
Yes,
So
Your Honor.
find a nonprofit that's registered with the IRS as a nonprofit, do your hours, official letterhead that shows you did 20 hours and send that to us within 60 days. If you want us to pre-approve it before you spend the time, then you can go through our email and email what you're thinking, and we'll let you know whether or not that's going to work.
Yes, Your Honor.
Can you pay the money on line today, or do you need some time?
I need some time, Your Honor.
All right, how about 30 days on the money?
Yes, Your Honor.
All right, so within 30 days, the money, and then within 60 days, the hours.
Yes, Your Honor.
Any questions?
No, Your Honor.
All right, good luck to you. Stay safe.
Yes,
Thank
sir.
Judge, thank you so much.
All right, John, I think you have one left and then you
Okay.
should be good to do the lives. I'll move
Okay.
you in.
Thank you so much, Heather. Thank
You're
you.
welcome.
Good morning, Mr. Greco.
Good morning, Judge. And we just had a civil infraction plea involving Ms. Elizabeth Ellison for TC October that we just gave to Heather for her to
Alrighty.
process.
Okay,
Thank you.
thank you.
Mr. Benavides, do you need to speak to your client?
No, we're ready.
You ready? Alrighty.
Yes.
Judge.
Elizabeth, you can go.
Thank you so much. Can I have 14 days, Heather?
Yep, I'll put it down.
Thank you.
Are you pulling Ogden?
No, I need to pull.
Counsel, your appearance on Ogden?
Good morning, Marcel Benavides on behalf of Mr. Clinton Ogden.
And Mr. Ogden, are you there?
Yes, yep.
Thank you. Counsel, I understand this is a dismissal. I'm going to bet that you and Mr. Ogden are okay with that.
We are, Judge. May asking for dismissal with prejudice that
It won't be with prejudice because I don't have a jury impaneled and I haven't sworn in a witness.
that's fine, Judge. Thank you.
Mr. Ogden, did you post any cash bond?
I did not.
Then the case is dismissed. You're all set. You fellas have a nice day.
Thank you.
Awesome. Thank you. Thank you, Judge.
Mr. Kewen, are we ready on Thompson?
We are ready, Your Honor. I'm going to pull them out right now. Thank you.
All righty.
Your Honor, this is Attorney Benavides. May I ask a quick question?
Sure.
Will the clerk input the dismissal into the system so that the licensing sanction is removed? The 625.
Yeah, that'll be done momentarily. She's doing real-time dispositions.
Okay, great. Wonderful. Thank you.
You're welcome.
Have a great day.
Counsel, your appearance for Mr. Thompson.
Good morning, Your Honor. Tim QNP 64917 appearing today on behalf of Mr. Thompson, who's joining us today via Zoom. Mr. Thompson, can you state your name, sir?
Yes, sir. Good morning, Your Honor. Lance Thompson.
Thank you. Counsel, tell me about the plea.
Thank you, Your Honor. Today's the time and date set for pretrial. I've been able to pretrial this matter on a few different occasions with the city attorney. City attorney has agreed to dismiss the original count, which is an OWI case from the year of 2020, with the understanding that defendant would plead guilty to an added count of reckless driving from that same time and date. Defendant has been advised of his rights, in particular, Your Honor, his right to trial. He'd be willing to waive those rights and avail himself of the plea today. Again, Your Honor, this is a case from 2020. Currently, Your Honor, the defendant is at the Michigan Department of Corrections. He will be there for at least the next year with a significant parole tail to follow.
All right. And Mr. Thompson, how long have you been incarcerated already?
I've been here I've been locked up for a year and some months.
Okay. All right. And did you discuss your rights with counsel? Do you understand those rights and the options they give you?
Yes, Your Honor.
And do you understand the possible penalty for reckless driving?
Yes, Your Honor.
All right. Understanding all of that, are you pleading guilty freely and voluntarily to that charge?
Yes, Your Honor.
Did you drive a vehicle on October 10, 2020 in the city of Romulus?
Yes, Your Honor.
And what's the factual basis for the reckless, Mr. Kewen?
Thank you, Your Honor. At that time, sir, were you operating that vehicle well over the speed limit? In fact, were you speeding significantly while you were driving? Is that correct?
Yes.
Is it also true at that point in time, one of your headlights was out? Is that correct? And it was after dark?
Yes, correct.
And you were weaving in and out of traffic. Is that correct?
Yes.
Judge, and for purposes of this plea, we would stipulate that there was alcohol in the defendant's system at that point in time. And I would be satisfied with that basis. Would you be satisfied, Your Honor?
I am, counsel.
Thank you, Your Honor.
All right. I'm going to set Mr. Thompson, I'm going to sentence you to 93 days in jail, give you credit for time you've already served. File is closed.
Thank you, Your Honor.
Thank you, Your Honor. Appreciate it.
Thank you, counsel.
Good luck, sir.
All right. Thank you. You too.
Is that what we got here? What are we doing? I won't find it. Dustin? All right, ladies, give me just a minute. I want to get files so Heather, so she can keep working.
Thanks, Judge.
I'll just give you those. All right, appearances.
He's looking out of this one. That's you know, how we defended.
Thank you. Sir, you can sit. They train the attorneys to jump up. You're okay. All right, so I had a chance to look at the pleadings. Let's just go over the high points and I'll give Ms. Manarino a chance to respond.
Motion set aside to default judgment. It all arose due to issues surrounding my client's driveway, which the city has elected.
You just do though.
Oh, you're done?
Yeah.
Oh, okay. Just a moment.
Go ahead. I muted that.
Not the case, Your Honor. It's not being used for a drug draft. Basically, the whole issue had arose when my client had hosted a memorial gathering with friends and family, and they had warned the police at the time of this event, of course, because they just wanted to make sure that the city was aware if there were any issues. And basically, my client, Mrs. McAllister, was his wife, had received a noise violation ticket, which we had handled previously. This matter, Your Honor, is a completely separate ticket. It came as a surprise to my client because there haven't been any noise issues. at the time of it being issued. And, basically, Your Honor, we appeared originally, counsel and I had agreed for the first adjournment of the matter because my clients wanted to discuss directly with the city. My office had previously discussed with the city a few months ago as well, and then there were subsequent discussions that my client wanted to discuss directly with the city without both counsel present. So that meeting date was scheduled the second day after our original hearing here in court. So I had contacted counsel to request an adjournment so that our clients can go ahead and discuss directly. Counsel did not object to that adjournment, and unfortunately, there was a misunderstanding as far as that getting translated over to the court. I know my client be held accountable for that. If anything, I'll take the blame for that if I have to take the blame for it. So basically, at this point, my client does want to just get the ticket because again, there is no commercial use of this property, of this driveway whatsoever. So he does have valid defenses and meritorious defense in this matter, and there is good faith for this default to be set aside.
Your Honor, the strongest evidence of the commercial use of this property come from the defendant's own mouth. There is a website, there is business, there is promotional materials that he's posted on numerous social media channels. The memorial event was something he posted on TikTok inviting anyone who saw the video to. There were people in staff t-shirts, including the defendant. This is the idea that we're going to argue to the court that this is not a commercial business flies in the face of every single word that has come out of the defendant's own mouth. It's not remotely true. And so for the court to set aside the default based on a misunderstanding, I could see where the court would come to that conclusion, but the issue is there's not a meritorious defense using the defendant's own words about what the property was being used for. And I understand that there's going to argue that they haven't been using it recently, but the problem is that the businesses are still active businesses with the state. The videos were still posted, and what we would have would be the defendant's own word that he's not going to continue to use this property as a commercial property, except after the last time they told the township they wanted to do it, they continue doing it, because we gotta just follow some things. The issue is that the township has asked them to provide plans for what they're gonna do with the driveway. We had a meeting where council, the McAllisters, myself, the building department were all present. And during that meeting, the township made it very, very, very clear to the McAllisters that the way that the township is going to be comfortable that this is not going to be used as a drift track any longer is to remove the portions of the track that you can drift around, i.e. all of the curves and the corners. The plans they submitted were we're gonna leave the driveway as is and we're just not gonna use it. The township was not agreeable to that, obviously, because that was against our entire position. And we've been waiting for months now for them to submit new plans. It's been nothing but adjournment request, dragging it out. The meeting that they scheduled, the building department, they canceled at the last minute and have to reschedule it. The township's not asking for engineer drawings, but for whatever reason, defendant seems to think that that is what the township's requesting, despite the fact that the township has repeatedly said, we just need something that can be rough sketch, like just nothing formal, nothing engineered, but just something to give us an idea of what they're proposing, so we can have some discussion. We can't have discussions when their plan is, we're gonna leave everything as is, and we're asking you to trust us, when we've given you no reason to trust us. Then we're gonna keep our word. So there's really, the way that we conveyed, should have conveyed to the court that the quick case being adjourned was by notifying the court that didn't happen. And there's no defense to this ticket. There's obvious commercial use of the property from the defendant's own words. We would ask the court to deny.
All right, so counsel, even if I give you the good cause for the default, I don't see the meritorious defense.
We also provide some clarity as far as the company itself. That company, Sideways, is actually a clothing company. And my clients are in the process of getting an actual commercial-based drift track in place in a whole separate city with the proper licensing and the proper planning and making sure that everything is in place in order to have an actual drift track. That's not relating to this Van Buren Township property. It's completely separate. And like I said before, the main complaint was from that blood memorial event. Unfortunately now, whenever anyone in the community is hearing any type of noise, they're automatically assuming that it's my client. And that's not the case, because officers have appeared several times to my client's property, and they've all showed up and said, why are we here? Nothing is happening. At this point.
So let me ask you this, sorry to cut you off. I'm assuming, I know nothing about drift tracks, but from what Ms. Manorino said, this roadway has a number of curves in it, including like a loop. Is that right? Okay, nobody puts a driveway in like that. Nobody in the history of mankind puts a driveway in like that. So are you going to be able to establish at hearing that this other site that they've been working on has been in place since before November of 2025?
The exact timing goes, Your Honor, but I do know that it's something that's been in the works as far as, of course, them having a company that they're working on establishing and building up for this track purpose. And as far as the proposal goes, in order to handle the current driveway that's in place, my client had previously submitted a proposal where they wanted to build different structures on their property in order to make use of this driveway. My client's a car enthusiast.
But it's not a driveway. It's not a driveway, counsel. Under any stretch of the imagination, nobody puts in a figure-8 driveway. They put in figure-8 tracks. Motion's denied. $230 is what you owe us, Mr. McAllister. When you want to pay that? You can. So what's next? I mean, the problem's not resolved.
No, Your Honor, no, the default's been unpaid. Proceed with filing a motion to remove the driveway.
All right.
Thank you.
Have a good day.